view of Brother Ravi Bhatt as stated in the judgment.
I am conscious of the ordeals that arise from multiplicity of judicial opinions in cases involving constitutional questions. Here I consider it worthwhile to pen the present opinion given the significant nature of the questions involved. Polyvocality in the exercise of adjudicatory function may not necessarily be viewed with discomfort if complemented with judicial discipline. It is truly reflective of diversity of judicial thought. At the very outset, I have given my conclusions while agreeing with the opinion of Justice Bhatt. I will read the conclusions. The question of marriage equality of same-sex LGBTQ couples did not arise for consideration in any of the previous decisions of this court, including the decision in Navtej Nalsa. Consequently, there cannot be a binding precedent on this court. The reasons for arriving this conclusion are articulated in detail with Justice Bhatt. The rights of LGBTQ persons that have been hitherto recognized by this court are the rights to gender identity, sexual orientation, the right to choose a partner, cohabit and enjoy physical and mental intimacy. In the exercise of these rights, they have full freedom from physical threat and from coercive action, and the state is bound to afford them full protection of law in cases these rights are in peril. Third, there is no unqualified right to marriage guaranteed by the Constitution that qualifies it as fundamental right. I have given my detailed opinion. In one paragraph, I would read that. In my considered opinion, the institutional space of marriage is conditioned and occupied synchronously by legislative interventions, customary practices, and religious beliefs. The extant legislative accommodation of customary and religious practices is not gratuitous and to some extent conditioned by the right to religion and right to culture, constitutionally sanctified in Article 25 and 29 of the Constitution. This synchronously occupied institutional space of marriage is a product of our social and constitutional realities, and therefore, in my opinion, comparative judicial perspectives offer little assistance. Given this nature of marriage as an institution, the right to choose a spouse and the right to a consenting couple to be recognized within the institution of marriage cannot but be said to be restrictive. Coming back to the conclusion, right to marriage is a statutory right, and to the extent it is demonstrable, a right flowing from a legally enforceable customary practice. In the exercise of such rights, statutory or customary, the state is bound to extend the protection of law to individuals so that they can exercise their choices without fear and coercion. This, in my opinion, is the real import in the decision in Safin Jahan and Shakti Vahani. The constitutional challenge to Special Marriage Act 1954 and Foreign Marriage Act must fail for the reason indicated in the opinion of Justice Bhatt. Similarly, Justice Bhatt also rightly finds the semantic impossibilities of gender-neutral constructions of the Special Marriage Act and Foreign Marriage Act. On both E and F of his opinion, Justice Bhatt has exhaustively as to the reasons that they need not now be supplemented. I find no right to civil union or an abiding cohabitational relationship conferring a legally enforceable status cannot be situated within Part 3 of the Constitution. On this count, I too agree with Justice Bhatt, but I have supplemented it, in my opinion, having considered that there exists no unqualified right to marry. In the ordinary course, no occasion would have arisen for any further deliberation. However, as the learned Chief Justice in his opinion has arrived at a conclusion that there exists a constitutional right to a union or an abiding cohabitational relationship, it is necessary for me to express my opinion on this newfound construction. The learned Chief Justice locates components of the right to union or an abiding cohabitational relationship under Articles 19(1)(a), C, E, 21 and 25 of the Constitution. In my opinion, it would not be constitutionally permissible to identify a right to a union or an abiding cohabitational relationship mirroring the institution of marriage. The learned Chief Justice identifies tangibles and intangible benefits that is bouquet of entitlements that arise from state recognition and regulation of marriages. The Chief Justice further opines that the right to marriage is not fundamental. However, it is in these tangible and intangible benefits, the denial of which, according to the learned Chief Justice, must inform the reading of a constitutional right to an abiding cohabitational union. In other words, the benefits of marriage, however fundamental to a fulfilling life, do not make marriage itself a fundamental right, but they render the right to an abiding cohabitational union fundamental. I find it difficult to reconcile these two principles. I finally conclude, I will read the other last two. I also agree with the reasoning and the conclusions of Justice Butt with respect to constitutionality of regulations 5.3 of CARA regulations. I've concluded with what I strongly feel. I am not oblivious to the concerns of LGBTQ partners with respect to denial of access to certain benefits and privileges that are otherwise available only to married couple. The general statutory scheme for the following benefits, gratuitous or earned, property or compensation, leave or compassionate appointment, proceed on a certain definitional understanding of partner, dependent, caregiver, and family. In that definitional understanding, it is no doubt true that certain classes of individuals, same-sex partners, live-in relationship, and non-intimate caregivers, including siblings, are left out. The impact of some of these definitions is iniquitous and sometimes discriminatory. The policy considerations and legislative frameworks underlining these definitional contexts are too diverse and to be captured and evaluated within a singular judicial proceedings. I am of the firm belief that a review of the impact of the legislative framework on the flow of such benefits requires a deliberative and consultative exercise, which exercise the legislature and executive are constitutionally suited and tasked to undertake.
Thank you very much. Thank you.